Let's head to the Supreme Court on that petition by the Speaker of Parliament.
At all material times present to the application. At all times material to the present application, her ladyship, the Chief Justice of the Republic, who presided over the court, always knew that the supposed service on the first financial processes report was made in breach of the provisions of Articles 117 and 118 of the 1992 Constitution, as well as the agreed protocol for serving the first financial process report. Ladyship, paragraph 49 is even worse. And it says, additionally, the first defendant also expects the court to set aside the processes and proceedings which led to the said orders, so as to avoid being seen as seeking to overthrow the 1992 Constitution and or as merely subjecting itself to advancement of a partisan political agenda on behalf of the representative of a political party, more so when there is a process before the court had not properly involved use of the court. Ladyship, indeed, paragraph 21 imputes scandal and a deliberate attempt to embark on a course which may be deemed to be in flagrant violation of the Constitution.
Why? To
the court. It's because the deponent to the affidavit alleges that the Chief Justice who presided over the court always knew that the supposed service of the first financial processes was made in breach of the provisions of the Constitution. If a deponent to an affidavit in his affidavit says that the process was in violation or the service was in violation of the Constitution, there's nothing wrong with that at all. But for you to suggest that the Chief Justice always knew, even before the application was heard, that it was in violation of the Constitution, that with all respect imputes scandal to the court. I do not think it's proper. Again, paragraph 49 also indicates in very intemperate and offensive language that the first defendant expects the court to set aside the processes. Otherwise, it will be seen that the court is advancing a partisan political agenda. In this respect, this is a very important, serious matter before the court. In my submission, there is no room at all for the use of language which unnecessarily scandalizes the court and seeks to impute that the court is advancing any partisan political agenda. Indeed, the whole of the affidavit, with all respect, is even in violation of the rules of court, argumentative and court of view, but that is not even my main contention. The whole of the affidavit is actually in violation of every rule governing affidavit. But my main concern is the use of the language in paragraphs 21 and 49, which imputes scandal to the court and which do not serve any purpose at all. I really pray that these paragraphs be struck out. The greatest threat.
Right. My lady is just... Hold on. Mr. Abedu, do you have anything to...
My lady, there's just something, I was just overtaken because my lady said I should resume my seat and listen to him. I was going to draw the court's attention to the fact that I actually had an objection to raise with regard to the empanelment of one of the members of the court to sit in this particular matter. But subject to what the court will say, I will subsequently respond to the arguments. Actually, that was what when I said I had a motion, but I intended to raise that, and he just got up and my lady said I should resume my seat. So out of respect for the court, I resumed my seat.
All right, so since the matter at bar now is the paragraphs of the affidavit, do address it. I do give you my word that we will not rule until we have heard you on this issue of the panel.
Very well, but even the issues he raises...
So, hold on, hold on. There are two issues that you have addressed.
Yes, madam.
One is your alleged objection to a member of the panel. Yes. The second is hold on. You know the rules. Yes. The second is your response to the matter raised. That's right. And I'm saying that respond to the matter raised. Thereafter, we will hear you on the issue of the panel.
My lady, with regard to the objection that has been raised today, yes, my lady.
Because whichever panel sits on it,
yes,
this issue of this issue raised by the Attorney General, yes, will have to be addressed. And so respond to it.
So my first response is that the objection itself has been irregularly raised, because this is essentially an application to the court to strike out specific paragraphs of the affidavit in opposition, in support of the application. This must come formally before the courts. And although the rules of the courts do not expressly say that it should come by application, several authorities of the court say that where the rules of the court do not expressly say something, then it's the rules of the High Court that should apply. And in the provisions of Order 81, Rule 2, it is clearly stated that if you have an objection to anything done as contrary to the rules.
Rule 2 of CI 47, read it.
So this is what it says. Rule 2.1 says this: an application may be made by motion to set aside for irregularity any proceedings, any step taken in the proceedings, or any document, judgment, or order in it, and the grounds of it shall be stated in the notice of the application. And I just want to make a small point.
Maybe.
Yes, that's the point I was going to answer. May used in this context, as generally understood, is permissive. But may only means here that the party alleging the irregularity can waive it. It is in the sense as it was explained in Edusei versus Attorney General, the 1998-99 reported version, in which the question was raised whether the word may used in Article 33(5) of the 1992 Constitution meant that a person whose human rights are violated may decide, may apply. And they said the way the may there doesn't mean that you can decide to come by any mode. It even means that you can waive your fundamental human rights. But if you want to take the objection, you must come by application. That's my first answer. Secondly, I'll deal with the substance itself. It is argued that the paragraph 21 of the affidavit in support is scandalous. Now, the word scandalous is just used. I'm saying the whole reading of the whole of the affidavit would disclose the context of that particular paragraph. I have referred to an Exhibit D, which is the foundation of those depositions. The Exhibit D is a letter emanating from the Judicial Service, in which they make reference to discussions held between my lady, the Chief Justice, and the first defendant on potential breaches. So, if I make that deposition, I make it based on that one. And apart from that, yes.
Hold on.
The Judicial Service.
Hold on.
Yes.
The point you just made,
yes,
is that your paragraph 21
yes,
is premised on SBD.
yes.
All right, go on.
And
So go on.
Yeah. In that particular SBD, it's clear what the directive of my lady, the Chief Justice was clear. And so I'm saying, and if I say that at all times material, it was always within the knowledge of my lady, I am making it based on that. And if Madeleine reads Exhibit D, it says clearly that the Honorable Lady Chief Justice's attention has been drawn by the Right Honorable Speaker. This is all based on that. It's a statement of fact.
Please, just get on.
Then he talks about...
leave the commentary.
Oh, Madeleine, it's a submission, it's not a commentary.
All right,
all due respect.
Go on.
Yes. In paragraph 49, he says that the deposition that the first defendant also expects the court to set aside the processes and proceedings which led to
complete the reading of paragraph of SBD if you want to.
No, Malidi, you said the point was made and I was bearing to it. Yes, so I'll do it. So the basis of paragraph 49 yes, my paragraph 49 arises from the observations made by the court before its ruling on the basis of which it made the orders. And
your paragraph 49 is premised on observations by the court
made in the course of its ruling
in the ruling of
18th October, which is sought to be set aside in this application. In the fourth page of the ruling of the court, starting from the third paragraph.
Attached as?
Yes.
Attached as?
Exhibit B. There is a finding by the court that the applicant or the court observes that the applicant urges, and we appreciate that the said ruling would also likely lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruptions. And so the court then, on the basis of that, makes its ruling in Exhibit A and notes that.
No, hold on.
Point also, yes.
Hold on.
Yes.
So the partisan political aspersions arise from the observation of the court on the submission of the applicant in that time.
Yes, my lord.
At that time.
Yes, my lord. Because in the ruling of the court, if my lady looks at the second page of the ruling of the court, we will start from. The court makes the same observation. Exhibit B.
Exhibit A is not the ruling of the court.
No, my lord, those portions of the submissions that were made to the court were relevant and that informed the ruling. That's what it is. Yes.
Yes.
No, those were the proceedings.
Yes.
Mr. Sorry.
So it is not. Is not the ruling of the court. So just refer us to the proper exhibit, which contains the ruling of the court.
So I started from the proceedings and I'm now ending with the order. The order also the order just makes the same finding. If my lord take a look at the paragraph that says an applicant urges the court.
Where are you reading from?
After listing the parliamentarians affected by the ruling, there's the next paragraph which starts with the set for constituencies, and then it goes to say the applicant urges, and we appreciate that the ruling.
So you are reading from Exhibit B.
No, check A. The order that was sent. Yes. Yes. The cover letter is marked E, but attached to it is then the order of the court. And so that was taken into account before the court then makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex parte application, and they were heard. What was the balancing?
Sorry.
Yes.
I thought you were just responding to a very straightforward.
Oh, yes.
But now, the case that we are veering into the substance of the motion itself, I would urge you, rather, to restrict yourself to the objection that he raised and answer it, whether it is scandalous or it's not scandalous.
It is not scandalous.
My problem is,
yes,
if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My Lord, I needed to demonstrate that these things were not just said out of aim.
No, just restrict yourself to...
My Lord, I thought I was doing that. And so, as far as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before the court.
You allege that the Chief Justice is privy to breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that's a statement of fact,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve by adding the point that the Chief Justice was privy to a constitutional breach? I think that's the point.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
But Mr. Sorry, the ruling, if you don't mind, let me draw your attention to the fact that the ruling says that if you look at the first page of Exhibit A, we note from Exhibit B the official report on the parliamentary debates on Thursday, 17th October 2024, pages 15, 16, and 17, that the Speaker of Parliament was aware that bailiffs of the Supreme Court had served the current action on him through the legal office of Parliament. His objection to this proper service of a process from the Supreme Court was that it had not been done on a Monday.
Yes, ma'am.
That's what the ruling says. So the ruling was quite clear. The source of the notification.
Yes, ma'am. But that's even the source.
If I could learn.
Sorry, I thought my data finished. I'm very sorry. I thought my data finished. I'm honestly sorry.
Yeah. So the ruling was quite clear about the source of the observation that the Speaker of Parliament had been properly served. And the ruling appreciated the circular, administrative circular from the Chief Justice. The first Chief Justice was Chief Justice Edini Ebua in 2021, and myself issued another circular which clarified how all of Parliament was to be served. That is what you are referring to. Is that not so?
Yes, madam.
And how does that veer into a partisan political agenda, including constitutional breaches?
The two are independent. Let me deal with the first one. My lady says the finding even by the court that it was proper service is the point we are making. That by reference even to the parliamentary proceedings that took place that day, it was clear. It is not, first of all, it's not the official report because it was just a draft one. Parliament had not yet gone through it and adopted it as an official one. But the second thing is that the court could not have found without referring to the judicial circular in which the proceedings had indicated clearly that the first defendant was objecting that it was not in accordance with that. And the appreciated it. So that is it. And this, with regard to the partisan aspect of it, that one is distinct. It's a distinct point, and that one is based on the submissions made to the court that, based on the assumption that if one party is the majority, it is deemed that government business will be thwarted. That's based on that assumption. Because if the Speaker's ruling state then there was nothing to show that whichever party was the majority or otherwise, government business will be thwarted. And the Constitution doesn't assume that the government in power would necessarily have majority in Parliament. So those were the issues that were raised clearly on the face of the documentation.
Mr. Sorry, are we still addressing the preliminary legal objections raised by the affidavit, or we are dealing with a substantive matter, i.e. your motion to set aside the process?
Oh no, I'm dealing with that matter, but I'm also responding to questions from the bench showing why, if my lady says that it was based on the proceedings in Parliament, I'm asking that.
Kindly round up.
Yes, so my lady, there's nothing scandalous about it. They are based on matters of fact that arose out of the proceedings before the court, on the basis of which the court made the orders sought to be set aside. Yes, ma'am. Yes, ma'am.
Accuse that member of being, when the decision that is taken here is a collective decision. You isolate one member in your position and accuse that member of being leading to a constitutional breach. You think that it's a proper thing for us to make this?
Well, first of all, it's not a proper inference from the affidavit, because the person whose judicial, the judicial circular does not make reference to the full membership of the panel. Oh yes, yes, because she was named in the circular. The rest of the panel was not named there. Yes, but I'm giving the background to that application. I'm not accusing, and to turn it into an accusation, it's not a fair inference to be drawn from the affidavit. Maybe my Lord is borrowing his words, and then I have to answer.
Sorry, are you able to allow the court to tell you something? If the proper practice at the bar is when the judge starts speaking, you stop. Do you not appreciate that?
Oh, my lady, I don't think my Lord thought I interrupted him. I was just responding.
I beg your pardon.
Then you shall. It's a prosper, I don't speak. I don't
Are you able to let my Lord land before you start speaking? So we can have an orderly conduct of today's event?
So that's my worry I'm expressing. But when the court is, I don't think it's proper. I isolate from it. Whether she moves or she don't move. That's part of this. If you start doing accusations across the board, you should know better. I expect you to know better. But the other friend has raised an objection. I would have thought that the gentleman leading it was now seated. Because what you have done is to isolate the individual members of the panel and accuse them of constitutional breach. And you know how serious that is.
Can I answer? So, but I'm saying that it's not a fair inference from the affidavit, and with all due respect, we reflect the circular that had nothing to do with the panel. And so it wouldn't have been right. I would have been misrepresenting the circular if I put it in those terms.
Yes, Mr. Abedu, can we hear you on this preliminary? He's done.
No, but you see that.
But yes, he's done.
I totally associate the concerns raised by the Attorney General, and I have nothing more useful to add. Second.
Now, Mr. Sori, can we hear you on your objection?
Of the President arises from some of
So that my Lord, on the extreme what?
right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings.
said no. I think you said enough. Kindly resume this.
Very well, Malik.
Let's go. Registrar.
My Lord, with respect.
You gave your privilege of please stand. You gave your privilege of addressing the court to your junior. So we will not hear you. Not on these matters.
My Lord,
we will not hear you.
I apologize, I was sitting in Parliament. When the speaker is talking, you sit, you don't stand. So when I make this mistake, I said,
please, Mr. Gatti, we will not listen to you at this point.
Okay. When you're ready, when now you decide that you are...
Mr. Gatti, we will not listen to you.
I'm just saying that, my Lord, if
the court will rise now to give us...
Then you
all rise. Like seriously. So right now it's on. So you can hear everything you are saying. Why would you do that? Because you can have a family
issues that are been coming up. We expect that pretty soon the court will come back and give its ruling on these specific matters that have been raised by the Attorney General that allege that specifics of the amendment, specifically paragraph 21 and paragraph 49 of the amendments that were made by Thaddeus Ferry were all scandalous, all the Supreme Court and must be struck out. Again, Thaddeus Ferry, lawyer for the Speaker of Parliament, has raised some objection to the inclusion of Justice Ernest Yao Gaiwu as a member of this panel. We know that Justice Ernest Gaiwu is a former NTV parliamentary candidate in the Volta region, one of the constituencies there, and so objection has been raised as to his inclusion in hearing this matter that has a lot to do with the governing New Patriotic Party and its maintenance of its majority in Parliament. And so the court has heard these two objections, and we expect that any moment from now they will come in. We've seen their staff come up to take their seats, to just be around the seats to do so. But this matter specifically has to do with the ruling of Speaker of Parliament Alban Bagbin declaring 4 seats vacant about 2 weeks ago. We know that consequent to that, the NPP side, led by the majority leader Alexander Penya-Martin, filed an action at the Supreme Court seeking to stay that order and the ruling of the sort of the Speaker of Parliament. The court did hear that matter expeditiously and granted a stay of execution of the Speaker's ruling up until the final determination of this matter. As we see, the lawyers for the Speaker of Parliament have filed an application, a motion, asking the Supreme Court to vacate its ruling in regarding to this. So if ordinarily the Supreme Court grants this, it will mean that there will be no order that is stopping the hand of the Speaker of Parliament, and its order will be back in full effect. And so that was done. But just before the court will get into the specifics of that matter, the Attorney General, Godfrey Yeboah-Adame, raised an objection to some 2 paragraphs in the amendment in the actually affidavit that were filed by Mr. Thaddeus Ferry and his law firm. Paragraph 21 and 49. Paragraph 21 having to do with the fact that the Chief Justice was aware that the Speaker of Parliament was not properly served, and then paragraph 49 having to do with the fact that he wants the court to overturn this matter and all the issues that have come up. But Mr. Thaddeus Ferry himself had an objection of his own. He's objecting to the impandeling of the court. He's objecting to the addition of the Chief Justice. Another court is seemingly coming in now and then. See if they are coming to give their ruling.
Civil motion number J7/14/2024. Bright Asante Apia. Bright Asante Apia versus 1 Yumin. Sunlight Engineering Limited.
Respecting my laws, second defendant, appellant, applicant is represented by, please, your name. Conrad Asia.
We're bringing you live visuals there from the Supreme Court. Key case being heard today, filed by the Speaker of Parliament. If you recall, this all started when the Majority Leader, Alexander Afenyomarkin, went to court seeking interpretation of Article 97 of the Constitution. And he, as part of the reliefs he sought, was that the court withhold the Speaker's decision to declare 4 seats vacant after they declared their stance to run as independent candidates in the upcoming elections. Now, the court granted his request and asked that the Speaker stays the execution of his initial verdict that declared the seats vacant. The Speaker is back in court, is challenging this. Some of the key issues that has come up so far by the individuals in court. We know that the Attorney General is contesting 2 averments that has been raised by the suit filed by Thaddeus Sori, who is, by the way, representing the Speaker of Parliament. The Attorney General is representing the state. And then we have Atacha on the other side, as well as other lawyers representing Alexander Afenyomarkin. So some of the key issues that have come up is a controversy. 2 averments that the Attorney General is contesting. Paragraph 21 and 49. Paragraph 49 states that the first defendant also expects the court to set aside the processes and proceedings which led to the said orders so as to avoid being seen as seeking to overturn the 992 Constitution or as merely subjecting itself to the advancement of a partisan political agenda on behalf of the representatives of a political party, more so when the writ and processes before the court had not properly invoked the jurisdiction of the Supreme Court. Now, paragraph 21 states that at all times the material to the present application, Her Ladyship, the Chief Justice of the Republic of Ghana, who presided over the court, always knew that the supposed service on the first defendant of the process of the court was made in breach of the provision of Articles 119, 117 and 118 of the 992 Constitution, as well as the agreed protocols for serving the first defendant with processes from the Supreme Court. These are the specific paragraphs that the Attorney General, Godfred Yeboah-Dame, raised concerns about it. He termed it scandalous, and he is actually pushing that that be struck out from the case, the affidavit filed by Thaddeus Sori. He says it's in breach of the court rules, and he wants this paragraph struck out. Thaddeus Sori says that he's opposing the panel. So if you just tuned in, there's a panel sitting on this case. The Chief Justice, Gertrude Tokono, makes up that panel. Justice of the Supreme Court, Mariam Owusu, Kwame Asiedu, Miao Darko Asare, and Ernest Geu, all justices of the Supreme Court. I told you earlier that Thaddeus Sori, Justice Sai, is representing the Speaker of Parliament. I also told you that Parkway Siedu, Jogate, Atachian, they're representing Afenyomarkin. And then Godfred Yeboah-Dame is representing the state. Now, Thaddeus Sori is raising objection to the panel that is sitting on this case. He feels that the panel ought to be changed. He raised specific concerns about Ernest Geu. He wants him out of the panel, and he states that Ernest Geu is a former MPP parliamentary candidate. That's one of the key concerns he raised on the floor. He wants him out. Initially, when the case started, the Chief Justice had given each of them 7 minutes to make their point. However, Thaddeus Sori raised objections. He wanted 10 minutes, and so that case is currently in court being contested. Some of the 2 key issues that have come up is that, one, the Attorney General is raising concerns about 2 averments, and he wants that struck out, raises concerns about it, which I have read to you. And then Thaddeus Sori is also raising objection about the panel sitting on this case. So we're live in court. We're giving you updates as it happens in court. This is Newsdesk. Stay with us.